Okay,
We're recording.
Mrs. Ortega, could you please raise your right hand, swear to tell the truth, nothing but the truth?
Yes.
Okay, who else is going to be testifying?
My husband Miguel and my son Miguel Jr.
Okay, yeah, we'll start with your husband. Could he please raise his right hand, swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Miguel Jr.,
Right
could you
here.
please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, I don't have to swear the interpreter in, right, Ryan?
No, you do.
I do?
Yes.
Okay, Stephen, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, is that everyone?
And Wayne, I think you just want to also have the interpreter testify that they'll faithfully translate from Spanish to English and English to Spanish.
I do.
You do? Okay, great. All right. So
Excuse me, this is the reporter. May I please have the interpreter's full name?
Yes, my interpreter ID is YM288, and my name is Stephen Aubain, Aubain.
Thank you.
Okay, John?
Yes, thank you.
Okay. All right, let's get started. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Agoos, board member.
Ryan McSherry, board counsel.
Philip Motto, board's administration.
Thomas Rybakowski, City of Philadelphia, License and Inspections.
All right. Is that it? Okay, Tom, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay. My name's Wayne Miller, board member.
We already
Mr.
did.
Miller, can I read this one into the record?
All right. All right. Tom, you want to give us a little bit of what's going on with the case?
Can we put that on the record first, sir?
Oh, yeah, read it for the record. Yes, I'm sorry.
MI 2024-007-215 for the property 323 East Ontario Street. Miguel Ortega Jr. is the appellant. He's present in the room, sir.
Okay.
So
All right, Tom, go ahead.
So what we have is the property at 323 East Ontario Street was declared unsafe back in following a fire that occurred on or around May 16th of 2022, with a notice being sent out around that time.
And this is the interpreter speaking. Do you want me to start interpreting now?
Yes. I'll pause.
Thank you very much. Así que el tema del caso es que en la dirección de 323 East Ontario Street hubo un incendio en mayo 16 de 2022 que causó que pusieran una nota que la propiedad estaba insegura.
I believe this should be dismissed as an untimely filing.
Yo creo que esto debería de ser quitado debido a que fue sometido fuera de tiempo.
In that the owner is not disputing the violation, they are disputing that the permit or the work was completed under the permit.
Y que el propietario no está disputando una violación, están disputando que hicieron el trabajo con el permiso.
They filed this appeal in response to receiving the final notice instructing them that the property was still in violation. Instead, they could have reached out to the department themselves. So with that matter, this matter should be dismissed as untimely, and then they can resolve the matter with the department on their own.
Ellos hicieron la apelación porque habían recibido una nota final de la violación, pero ellos pudieron haber contactado el departamento por su propia cuenta. Por eso es que estamos pidiendo que quiten esta apelación debido a que fue sometido en el tiempo inadecuado y ellos lo pueden resolver por su cuenta.
Okay. Is everything good now with that?
¿Y todo bien con eso?
Escuchamos lo que dice el inspector, pero si puedo decir algo, es que nosotros hicimos lo que nos pidieron, pero mi esposo estaba pasando por un proceso de salud, de radioterapia, de cáncer de garganta, y yo de verdad que no tuve mente solo para atenderlo. aparte.
Permítame. So, I heard what the inspector said, and we've done everything that was asked of us. And the thing is that my husband was going through some health issues that my mind was solely focused on helping him.
I understand that, but unfortunately, that's irrelevant. The contractor that was listed on the permit
Así que, desafortunadamente, yo entiendo eso, pero eso es irrelevante. El contratista que está listado en el permiso
did not call for inspections.
no llamó para las inspecciones.
So then the permit was expired.
Por eso fue que el permiso fue vencido.
If they call the department, we can work with the appellant in resolving the matter without the board, as this is an untimely filing.
Pero si llamamos o si llaman al departamento, ustedes pueden resolver este tema sin involucrar a la junta.
Y pregunto, puedo, o sea, no estamos evadiendo lo de la violación ni nada de eso, sino el próximo paso sería que yo llame y hable entonces con el departamento para ver cómo hacemos con eso, con ese caso.
So, I'm not disputing the violation. So what would be my next step? Do I need to call the department and see how they could help me resolve the issue?
Yes.
Sí.
Por favor, si me pueden dar un número para yo comunicarme con la persona directa con
And
la que tengo que hacer cita para ir allá y hablar y resolver eso.
would it be possible that I could get a direct phone number to the department that I need to call and make an appointment with?
Actually, I would give them my number, but if is there a representative there that would speak English?
And this is the interpreter speaking. So can you please repeat what you said so that I could interpret it?
They could contact me. I would be happy to give my number, but would there be somebody that would be able to speak English to illustrate what needs to be done?
Así que yo le puedo dar mi número de contacto para que me puedan llamar, pero ¿habrá alguien que sepa hablar inglés que se pueda comunicar conmigo?
Sí, por favor, me lo da y yo le consigo a esa persona.
Yes, if you provide the phone number, I'll have someone that can speak.
215. 686. 2583.
The interpreter requires verification. Did you say 215-686-2583?
Yes.
Así que el número de teléfono es 215-686-2583.
¿Y el nombre de él, por favor?
And the name?
Tom.
Tom.
Okay. ¿Qué día puedo llamarlo? ¿Y a qué hora?
And what day and times can I call?
You can call me tomorrow morning after 8 o'clock.
Mañana por la mañana después de las 8 de la mañana.
Ok, gracias.
All right, thank you.
Okay. Thank you very much.
Hold on. No, the board needs to make a decision on the record. There was a request to dismiss the matter as untimely. Are you doing so?
Amy, you in favor of that?
I'm in favor of dismissing so that they can settle it
No, outside of this, yes.
with CSU.
Yes.
Ted?
Yes.
Okay, and I'm good with it too. Okay? All right, guys, good luck.
Thank you.
You're welcome.
Thank you, Deborah.
All right, do you require further interpretation?
Hello?
Hello, do you require further interpretation?
No,
I
so
don't
that was
believe
the
we-
only case we brought you in for was this one.
Okay, well,
Thank
thank
you
you
very
for
much.
using our service. Interpreter
Hey,
disconnected.
Steve, thanks, Steve.
Thank you so much.
Thank you.
All right. Okay.
The next item
Next
today,
case.
sir, is MI 2024 007471 for 1447 South Napa Street. Teresa Warren is the appellant, and she's present on the telephone today, sir.
Is she doing the telephone?
Yes, sir. She
Okay.
did not have the ability to hook up.
Okay, we'll swear, okay. Teresa, you hear me?
Yes,
Okay, I'm gonna swear you in, because you'll be testifying. Is there anyone else with you?
no,
Okay, could you please raise your right hand? Swear to tell the truth, the whole truth, nothing but the truth?
yes,
Okay, what we'll do is get started. I'm Wayne Miller, board member.
Amy Rivera, board member.
okay,
Ted Agus, board member.
Ryan McSherry, board counsel.
I'm
Philip
Matthew
Motto.
Wojcik,
Go ahead, man.
I'm back. I'm Matthew Wojcik, supervisor.
Philip Motto, board's administration.
Okay, Tom, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, thank you. Phil, could you read that into the record?
Yes, sir. This is MI 2024-007-471 for the property at 1447 South Napa Street. Teresa Warren is the appellant. She's present, sir.
Okay, Tom, you want to tell us a little bit about this case?
So this property or this hearing in front of the Board of Building Standards is for the property at 1447 South Napa Street. The property was declared unsafe following an inspection that occurred by the department where there were issues with the exterior masonry or brickwork resulting in the designation. The appellant does not dispute the violations on the appeal form. The appeal form is asking for additional time for them to apply for a permit and repair the property. In the interest of time, I'll go through and show the photos that have been taken of the property, but we would be looking for a permit to be in our system within 60 days for the repair of the property. So I'll share my screen now.
Good, Tom.
Can everybody see my screen?
We see the screen, but the pictures aren't up yet.
How about now?
Yes.
Yes, they are.
So here's the rear of the properties on Napa Street. It is the GPS location shows that it is 3108 Dickinson, but that's because it was taken from the rear or from the driveway. So the GPS picked up a different address. But as I scroll through, you can see that there are issues with the exterior wall of this property, and also the posting that was affixed to the front of the property. Again, the appellant does not dispute the violation. They are just asking for additional time to make the necessary repairs on the property itself.
Okay. Mrs. Warren, what do you have to say about this?
okay. When I first got the violations, I tried to get help. I went to 1234 Market Street for them to help me to see if they could help with the back, because that's what it was for, the back of the wall. And they approved me and said that, and they approved me, you know, with my income and stuff, and they came out and stuff, but they said I had to get some clutter out my house where they was going to do the back wall. So I had to pay somebody. I did all that. I got all that done for the back wall. My back of the 2 bedrooms is connected to the back wall and everything. I did that. And then after that, it was hard for me to get any kind of, okay, yeah. So I was trying to get help to get all that done. And then after that, I was going back and forth with the license and inspection and stuff. And then at one point they told me it wouldn't be enough money for them to do that whole back wall. So what I tried to do was try to get different organizations to try to help me to get the back wall done. because they said that I guess that they only had so much to give people at 1234 Market Street, and around 20,000 went due. So I tried to go through restore, repair, whatever. They wouldn't do it. Nobody would give me anything because I had a violation, and plus I needed insurance on this house before they could even try to give me any type of money. So it took me so long, and eventually I did get a insurance company to give me the insurance so I could try to get a loan to get this fixed up, to get the wall fixed in the back. So in September, I believe, of this year, I got the bank to give me a loan so I can fix up the back wall. And I called 3 different contractors, and I picked this one contractor to do the work. And I gave him money, I think in early September, in October, for him to get the permit. He told me, let's hurry up, get it done before it get too cold, that he needed the money to get the permit so he could start doing the work. So I'm waiting and waiting and waiting for him. But I did get sick, so I was waiting for him, and nothing happened. So I called him and let him know that I had make a long story short, I gave him money I gave him money to get the permit. He never got the permit. I asked him what was going on with the permit. And he never did get the permit. He also called me back in between, sometime in October or November, he was claiming that he needed to get permission from the person that lived next door to me, the 2 people that lived next door to me, to get work done, because he said he might be dealing with their wall or something. He was like making excuses, and I didn't trust him, so I asked him to give me back my money so I can because I called 3 other people so I can get my work done, because I'm on a fixed income. I don't have money. I got saying that I had to pay all these the violation 2,000. So I don't have money, and I'm trying to get the money back from him so I can get it done, because I do have a few other contractors, and that's the problem right now, to try to get the money back from him.
Okay.
Mrs. Warren, Mrs. Warren, is this contractor licensed with the city? Do you know that?
Yeah, he said he was. He said when I gave him the money, he was supposed to, the day that he got the money, he said he was going to go over to City Hall to get the permit. He never did get no permit.
So, Ms. Warren, I only have one question or one comment, and then the department will rest. So your contractor, whoever that may be, and I don't know who that contractor is, but in speaking with the department asking or if there would be an effect or requiring of the adjoining properties to sign something or being notified, that is actually true. The department does ask for notification to the adjoining properties when work is going to be getting done. So the contractor did not mislead you with that statement. That said, I'd be willing to push this to 90 days for a permit to be in our system. With that, the department would rest.
Okay. Here's my question. My question is, who is the contractor?
The contractor, the name of the place is called Excavation Concrete. And the man that I was dealing with, well, I guess the owner of the place is called, his name is Morad. And the man that I was basically talking to, his name was Reese. But then once I told them that I had a court order and stuff, because I asked him that he have to come out to look, like look inside the house. He told me no at first, and then he said he looked at he said he already seen the back. But then when I told him that I was getting, a letter saying I had to be to court, he's going to say, well, I need to come out to look at your house. So he came on a Saturday to look at my house, but then he said he can't look at the house because he said that I have a cat or something because he smelled cat. I said I don't have no cat, and he wouldn't come in to look at anything. But in the long term, I really think this man he just was using me. I mean, like trying to just make excuses. And I just asked him because at this point I didn't trust him, and I was just asking him, can I get my money back? All the money that I gave him so I can try to get these other people to do my work for my house because I have nowhere else to go. I have no money. I'm paying back a loan that I haven't even gotten no work done. Every month they take my money from me. I don't even have no work done.
Miss Warren, have you been approved by PHDC, the funding agency over on Market Street?
No, because they didn't have enough money. I went to my own bank and got a loan to do this work.
So
is nobody? No.
I understand that. So there's two comments that I have. I don't know about this contractor. There's no permit in our system. You would have to get a licensed and insured contractor. You have two options. You could go to L&I's website and go down the list of contractors and do your due diligence and do your research and find a licensed contractor that way. Or you could call PHDC. They have contractors that are on file that they may be willing to work with you, or just have a referral of one of those contractors. Even though they're not doing the work, they may have a contractor that they could refer to you. But with that, I mean, I understand your plight, and I understand that you're testifying in front of the board or telling them through all the ordeals you're going with. I'm just going to let the board know all that's irrelevant. It's basically just asking for more time. I'll rest.
Yeah, so you said the place that you said call 1234 Market Street and ask them, do they have any contractors? Is that what you're saying?
Yes. I can't refer any of them. I can't specifically name contractors to you. It's unethical for the department to name one contractor over another. What I can tell you is you could go to L&I's website and download an entire list of contractors and do it that way. Or you may want to reach out to PHDC and see who one of their contractors that they would recommend.
Okay.
And if you're considering using one of the other contractors you spoke to previously, it's important to make sure that they're on that list and that they are approved by the city if you're going to go to one of them.
So go to L&I website for contractors. Is that what I'm supposed to do?
Hold on. First of all, is this, not that Mrs. Warren, this ain't for you. Can we look up and see if this contractor is licensed? There's a website. Give us it, Miss Kelly or Miss Warren. Please give us that name of that company again.
It's called Excavation Concrete. It's
Excavation Concrete, right? Is that the name of the company? Okay.
Yes.
Is Excavation Concrete a licensed contractor?
Wayne, I am on the Find a Licensed Contractor city list, and nobody shows up under the words excavation concrete. I also did a search for Murad. There is a IL Murad listed with an inactive license. Inactive since 2006.
Okay, let's get the reality now. I know the city can't recommend things and stuff like that, but I'm not going to sit here and a woman who paid, how much money did you pay to this contractor?
I gave him like 20. I think it's $21,000 or $20,000 from the loan that I got from the bank, and I want to try to get my money back. I want to try to get all my money back.
Okay, all right, Miss Warren, hold on. First of all, we're telling her to go and get another contractor. That means another $20,000. She don't have that. She don't have the 20,000. She just got a loan for 20,000. Now we're asking her because this piece of garbage contractors that ain't licensed, okay, or play games. If we have their address, we put that down so they can never do work in this city again. This is what happens to a lot of people, and we just brush it by. I think it stinks. This is what happens. $20,000 is like $1 million to this woman. And this piece of garbage stole that money. What do we do to go after that contractor? Because she's not going to be able to get another loan for 20,000. She can't even she can't prove that she did any work. The guy took the money and his license inactive. And we're going to let that go. Mrs. Warren, who was your city council member? Do you know?
No, I think it's no, I think it's Jordan Harris. I mean, what's his name?
He's a state rep. Jordan Harris is a state rep.
Oh, well, I don't know. I don't know.
If you know Jordan Harris, you can go to him. You can go to him.
But right, so let me say this too. Also, I had so what? Because he was saying that he don't mind giving me the money back or whatever and stuff, but he was only going to give me $17,000. But let me say this: I do, and I don't even pay. I do have a lawyer, and he was saying that we're gonna have to, because he hasn't gave my lawyer the money back, and he said that we're gonna have to try to call the police on all this stuff because he hasn't given me my money.
Okay, how will we make a complaint that this guy never does business in this city until he gives that money back? How do we do that, Ryan? How do we do that?
That's something I'm going to need to look into if we have the authority to be making a complaint on behalf of an appellant. But I don't have an answer for you right now.
The thing is that she was just rifled at $21,000. $21,000. He's going to give her 17 back. Now she had to get a lawyer. This is not fair. It's not fair. Mrs. Warren, we'll give you 90 days, and you find out, okay, from whatever can be done to recoup your money, and what does she do to file this complaint with the city that this contractor took her money and never did anything? What do we do then? What do we do?
I think we direct her towards her city council person.
Okay.
I can look up and try and determine.
It's Johnson, by the way. I looked it up.
Kenyatta Johnson. Okay.
Yeah.
Okay, Mrs. Warren?
Yes.
Listen to me. My name's Wayne Miller. Okay?
Mm-hmm.
All right? You go to Kenyatta Johnson. Okay? Councilman, he's the council president. You tell Council President Kenyatta Johnson that Wayne Miller, you were in front of the board, and he told you to come to him. And you need help. And I'll guarantee you, Kenyatta Johnson will help you. And we'll give you 90 days to do that, and then let us know what's going on. Stay in touch with Tom Robakowski, okay? But go right away to Kenyatta Johnson.
Do I have his
what's
number?
going on here?
And try to get his phone number and call him and say that Wayne Miller told me to call you.
Yes,
and tell
from
him
the
my
Board of Building
situation.
Standards. You tell him that.
I have the phone number too. It's on Atlas.
Okay.
It's,
Can we have Kenyatta Johnson's number?
Yeah, it's a 215-686 3412.
3412?
Yep. And it's City Hall room 494.
Okay, did you get that, Mrs. Warren?
Yes, 3412.
215-686-3412.
3341 to there.
Make sure you use my name.
Okay, Wayne Miller.
You make sure you use my name. And
All
then you have
right.
90 days, and if anything can be done in the meantime, that you recoup your money, you gotta get back to us, and then, you know, we gotta get something done in 90 days, and I'm sure Kenyatta, Council President Johnson will help you,
Okay.
okay?
All right. All right. Thank you so much.
So you have 90 days, but you're gonna have to stay in touch with us. Tom, do you have her number?
I have the number on the appeal form.
Okay. All right, let's get on that.
Okay, Wayne, can I have your direct number too?
Yeah, 215.
Hello?
Yeah, go ahead. 215. 704. 704. 5747.
5747. Okay,
Yeah,
Wayne.
that's my cell phone number. Now I'll give you my office number. There's another one. 215 671 1692.
671
1692.
1692.
Okay?
Okay.
Go to Councilman Kenyatta Johnson and tell him.
All right.
And there's also I'm not sure if the appellant's aware of this. There's a few community legal services is an organization of attorneys that help individuals in situations such as this. I can give you their number. Maybe there's someone there who might be able to provide you some assistance. I can give you their number. It's 215 215 981
981
3700.
3700.
Yes, and I can't guarantee they'll be able to help you, but they are a community organization of attorneys that help individuals in situations dealing with issues like the ones you're currently dealing with. And I can't guarantee anything, but I do recommend you reach out to them. That they might be able to help you.
Okay.
Okay? And then then we'll get back to us, okay? You got 90 days, but we'll get this done as fast as you can.
Okay, I'm gonna try my best. I'm gonna get ready to call Kenyatta office.
Yeah, call. Make sure you use my name.
All right, I will.
Okay, all right. Good luck.
All right, bye-bye.
All right, bye-bye.
Thank you.
I hate when people go after people that don't have a dime and try to extract money from them. I can't stand stuff like that, okay? And the thing is, there's a lot of them contractors in this city that do that. We have the name of that contractor, okay? And what we have to do is we have to make sure he does not do any work in this city, okay? As long as he owes this woman money, and he should not do any work in this city as long as he has a contractor's license. When we know something, we got to do something. That's what we got to do. And this is a disgrace. And it happens all the time to these poor people. And they get away with it because they don't have money to fight or anybody in back of them to fight. But I'll tell you what, Kenyatta will take care of that. He's a good councilman. Okay, we'll move on.
I just want to confirm the record. Was that matter continued then for 90 days?
Yes, it's continued till we get that squared away.
Okay.
Okay. All right. Next case.
Mr. Miller, just as a housekeeping matter, item number 3 on today's list, 329 through 331 Fairmail, MI 2024007483, asked and was granted a continuance for today, so they will not be heard today.
Very good. Okay. Next case.
The next ready matter should be item number 4, sir. MI 2024-007-469, 1324 South 46th Street. Nathaniel Turner is the appellant. Is there anyone in the room today representing the interests of 1324 South 46th Street? No one is answering that call, sir. Notice of this hearing was sent to the address 1324 South 46th Street on December 16th of 2024. And that is the same address that was listed in the appeal, but no one is present and answering the call, sir.
Okay. Do we do the case with them not being here or make a decision?
The board, yes, that can make a decision, or they can simply say that they don't wish to grant the appeal because the appellant failed to appear.
Yeah, well, we don't feel like giving it, granted any decision because he didn't appeal. Is that
No,
okay with Amy and Ted?
I think we should let Tom present.
Okay, fine.
That's
All right, no
typically
problem.
what we do. We can allow the city to present its matter and present its argument, and then we can render a decision in the appellant's absence as they fail to appear.
I'm
Okay.
going to ask that basically this be city affirmed failure to appear when read into record.
Okay, all right. We'll go through the whole spiel. All right. Tom, please raise your right hand, swear to tell the truth, nothing but the truth.
Yes.
Okay, Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Brian McSherry, board counsel.
Matthew Ojigal, supervisor.
Philip Motto, board's administration.
Okay, Phil, could you read that into the record?
Yes, sir. This is MI 2024-007-469 for the property 1324 South 46th Street. Nathaniel Turner is the appellant. He is not present in the room. There's no one in the waiting room under that name. Notice of this hearing was made. Pardon me. Notice of this hearing was made on
December 2024.
2024 at the
Correct.
address listed by the appellant.
Okay. Tom, can you tell us a little bit about this, please?
We have the property at 1324 South 46th Street has been declared as unsafe for conditions of the rear exterior walls and also the rear second story addition or rear shed of the property that's in a structural distress. I'll share my photo of the property that was taken on a recent inspection that occurred in November of 2024. But with that matter, I would ask that this appeal be dismissed for failure to appear, city affirmed failure to appear. I'll share my screen now.
Okay.
Everybody see my screen?
Yes.
So these are two photographs taken of the rear of the property of 13, or they're in the case file for 1324 South 46th Street. You can see conditions of the rear wall, breezeway wall. You can see that lentils are missing and brickwork is failing. Also, you can see that there's deterioration of the rear shed and rear second story bay on the back of the property. With that, I'll rest.
Okay. Is there a time frame that you're given or just going to have it dismissed for failure to come here?
I'm asking that it be city affirmed failure to appear.
Okay. And what does that take in now? What happens?
We would move on to another line of enforcement, no action by the board.
Okay. Everybody, Ted, Amy, you good with that?
I feel in the past we've given people time. Like to give them 30 days or something for Tom to take action. We don't know why they didn't appear today. I'd like to give them 30 days.
Okay. Ted, you good with that?
Yeah, I'm okay with that.
Okay. All right.
It's probably what
30
we would have
days.
done if they had appeared.
Okay. 30 days to get it rectified.
To apply for a make safe.
Okay, makes sense. Okay, good deal. All right,
I just want to confirm, Phil, do you put on the record the date of notice and the address notice was sent to?
I did, yes, but I can do it
Okay.
again if you'd like.
No, that's fine. I understand. That's fine. Just wanted
you
to
read it
confirm.
in the beginning, Phil, December of 2024.
Understood. Thank you.
Mhm. Okay, next one, 1930 Moore Street.
Yes,
Is anybody here from 1930 Moore Street?
yes, I'm
Okay,
here.
where you at?
I'm here.
Oh, okay.
Yes, sir.
Steve, what's your name? Steve what?
This is my son's name. My name is
Oh, okay.
Audi
What's your name?
Christian.
Okay, Christian, how you doing?
Yeah, I'm fine, sir.
Okay, you gonna testify in this case?
Yes, sir.
Are you the only one?
Uh, just in case my son is going out, he's trying to help me because my English is not so
Okay.
good. That's but I'll try as soon as I can.
In that case, I think we may need to have an interpreter if you're not able to fully understand English in order to respect, you know, your rights.
Yeah.
Okay, can you understand us?
Yes, sir.
Did you just have problems translating back to us in English?
Sometimes, yeah,
Sometimes?
translating in English, yeah. Sometimes I feel a difficulty. So my son
Okay.
English better than me.
Is he there?
The son cannot act as an interpreter. That is not permissible. We would need to have
Oh, okay.
a neutral interpreter. We would need to
All
order.
right, I got you. Okay,
Excuse me,
Wait.
sir. Sorry, go ahead.
What is the
what do we
son's
do?
name?
Just
What is the son's
continue
name?
this?
What is your son's name?
Stephen.
Steve, okay. I was looking at the other name on the violation to see if that was potentially the
His
son.
name is Stephen, my son's name.
Mr. Christian,
Yes. Oh, sorry, go
I'm
ahead.
sorry. Thank you. What type of interpreter do you need, sir? For what language?
The interpreter can speak Indonesia.
Indonesian? Okay.
You sound pretty good to me. Okay, so what do we have interpreters right there?
No, sir. We're going to have to order that. So we'll have to continue this matter.
Okay, we're gonna have to continue it. All right.
We'll send Mr. Christian a new notice saying what the new date is going to be. But we'll do that and we'll schedule the interpreter to be here for that date.
Yeah, okay.
Okay, this isn't imminently dangerous, is it, Tom?
No.
Okay, all right, fine. Okay, we'll get an interpreter and it'll be continued. We'll be in touch with you, all right?
Okay, thank you, Mr. Wayne.
Oh, you're okay. No problem, pal.
Yeah.
All right.
Bye-bye.
Okay.
Thanks, sir.
Number 6.
Sir, as a housekeeping matter, number 6 has also been continued. That's
Gotcha.
MI 2022-005-997 2912 South 13th Street. It was a request for continuance, which has been granted by the board.
Okay, good. Next case, Lansdale Avenue. Okay. Is anybody here from Lansdale Avenue? Going once? Going twice? Is anybody here from Lansdale Avenue? All right, nobody's here.
Mr. Miller, the appellant listed in the case is Mohammed Jabi. Mr. Jabi listed an attorney. I have this, excuse me one second, forgive me.
Yeah, take your time.
Mr. Jabi. Mohammed Jabi listed 3807 Chichester Avenue, Upper Chichester, Pennsylvania, 19061 as his address. That was the same address that was listed in the appeal. Notice of this hearing was sent to that address on 12/18 of 2024. We have a resident in the room answering to the call.
Okay,
Your son out as well.
excuse me? I didn't hear that. Did somebody say something? Dad, did you say something?
Son out. I don't think he.
In his appeal, Mr. Jabby says that he has a contractor who is trying to obtain city licensure and he just needs more time.
I believe this needs to be read into record because we have a standing issue.
Absolutely.
What kind of issue do you have, Tom?
A standing issue,
What do you mean by that?
meaning he doesn't own the property any longer.
Oh,
I would say that's an issue.
all right,
What
let's
do we
read
do
the-
with that?
Well-
Right?
You have the ability to dismiss it for lack of standing. If he doesn't own the property, he doesn't have the standing to appeal on behalf of, I believe it was issued to an LLC, and if he doesn't own the property, he doesn't have standing to file this appeal.
Mm.
Wow, so we're saying we know there's a violation and we're gonna let it go, and we don't know who else is gonna pick that up? Is that right?
So from a department standpoint, notice has been sent to the new owner of record, and also there is a permit under review under that new owner.
Yes.
Oh, he has a permit under review?
Not him.
That really has no reflection on today's case or matter. It's basically, they filed an appeal under the elite real estate, and they transferred the property to a AAA contract group LLC. So being that there's a recorded deed, as of November of 2024, they no longer have standing as they are not the owner of the property.
That's Mr. Jabby, right?
That is Mr. Jabby's entity that he has on the
Okay. So now it's the LLC.
Now it is the responsibility of AAA Contract Group to repair this property. And if they disputed the violation, they would have to file the appeal to this appellant board.
So
Okay,
this,
when you sell a property, do they know that there's an issue?
They're supposed to pull a property cert. Does that always happen? No. But when we learn of a property being transferred, the department does send notification to the new owner of record.
Have we sent notification to the new owner?
We have.
Okay, so now we're waiting for him to get in touch with us again on this issue.
Well, being that there's a permit that's also under review under the new ownership group, I would anticipate that this property being repaired.
Okay.
so it sounds like we should dismiss this.
I'm saying that it should be dismissed as a standing issue, but it should be read into record.
Okay. All right. Do we have to go through our
Yes.
the whole protocol? Okay. All right. Okay. This case is Lansdowne Avenue. Okay. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Ryan McSherry, board counsel.
Matthew Ochiko and I, supervisor.
Philip Motto, Boards Administration.
Okay, this case is going to be dismissed because of a new owner, and something was sent to the new owner, and that's why we were able to dismiss this case and waiting for the new owner to get back to us, right?
Is it should,
Tom.
there was a request, sorry, maybe we have to spare time.
For the tell truth, nothing but the truth.
Yes.
Okay.
So in the matter of today's appeal for the property at 5454 Lansdowne Avenue, in researching in preparation for today's proceedings, the department has found a new recorded deed transferring the property from the appellant Elite or Elites Real Estate to a AAA contract group LLC. I will share my screen and show a copy of that recorded deed as a matter of record. But with that, I believe that this is a standing issue, and this case or this appeal in front of this board should be dismissed as this appellant has no standing as they are no longer the owner. Can everybody see my screen?
Yes, we see your screen.
Yeah,
So
we understand.
here's a copy of the deed. It is actually a deed of correction. The original deed that was recorded approximately a month before that was for Elite to a different entity, and then they recorded a deed of correction transferring the property to this AAA contract group. But there's still a deed transferring the property, which means that this is a standing issue. With that, I rest.
Okay.
Can we take a brief executive session just to discuss the procedure?
Sure. Okay. Let's go to breakout room. Is everybody back? Okay. For this case on 5454 Lansdowne Avenue, we are dismissing it because Mr. Javi has no standing. Okay? End the case. All right. What's the next one?
That's it for me. Everybody enjoy the weekend.
Okay, Tommy, have a good one.
You too.
All right, pal. All right, now we got
We're going
a
to be
lot of
starting
refusals.
on.
1, 2, 3, 4, 5. Okay, let's get rolling.
All right, I'm going to bring the appellants in. They're in the break, or they're in the waiting room.
Bring them in. Bring them in. 1 South Christopher Columbus Boulevard.
Hello, everyone.
Hello, how you doing?
Good. Thank you so much for your time again today.
Okay. All right. We have 4 cases for 1 South Christopher Columbus Boulevard.
Yes, sir.
Okay. All right. Well, we'll get started. Who's going to be testifying in this case?
I can testify on behalf of the RWC.
Is that, what's your name, John?
Philip Boris.
Oh, Phil, I see Phil. Phil, okay, you're going to be the only one testifying?
I'm not sure. I know that Joe Forkin and Lizzie Woods were going to also be here, but I can testify on their behalf. I don't see them in the meeting yet.
Okay, okay, Phil Boris. Okay, Phil, can I swear you in?
Yes,
Are you
sir.
a lawyer, by the way?
I'm sorry?
Phil, are you a lawyer?
No, I'm not.
Okay, I'm gonna swear you in. Please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Agus, board member.
John Dimes, Fire Code.
Rodney Sherry, board counsel.
I'm Matthew Wojcik, LMI supervisor.
Philip Motto, boards administration.
Okay, Phil, could you read that into the record, please?
Yes, sir. This is MI 2024-007-147 for the property 1 South Christopher Columbus Boulevard. Hinge Collective and Ari Miller are the present. I believe Mr. Miller is present, but it's listed as Hinge Collective on your screen. And Mr. Borst is here as well.
Okay, Mr. Miller, are you going to be testifying? You're on mute.
You can swear me in case I need
Please
to.
raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay, all right, whoever's going to present the case, go ahead.
Okay, so thank you again for taking the time with us. If you don't mind, we'll start with the tents. So when we left the last meeting, our goal has been trying to find a way to make sure that we can make everyone comfortable. Since then, we've submitted or attempted to submit to Eclipse, but I believe we submitted to Ms. Richardson a number of different documents. And it's sorry. Hello? Hello?
Who's that?
It's okay. They've muted themselves.
Oh, okay, go ahead.
So we provided a letter. We're trying to provide an operational solution. So the Winterfest itself has had the tents up for over 2 decades, and operationally, if there's a snowfall, what would happen is we turn the heat up inside the space so that it wouldn't accumulate. And then we would also remove the snow with operational staff if there was anything up there. But there's also procedures for the safety of the community, and that is it's shut down if there's ever a collective, volume of snow. So in your packet, we submitted a standard operating procedure and a letter authored by Joe Forkin, the director, CEO of the DRWC, to where we commit and they commit in signature to these operational solutions. And we're sort of hoping and begging that these could kind of help get us through. Because the tent are only supposed to be here for the period of time until we can move the permanent Winterfest up onto the cap when the I-95 cap project is completed. So specifically, if I could draw your attention to the SOP, if there's a forecasted snow event, we will put the heat to its highest capacity so that the snow would not collect on the roof of the tent. If it's to exceed 3 inches, we will shut down the event. There'll be no community people in the river rink. And then under a snow removal plan, we have in there that our staff will remove snow if it does accumulate. If it's more than 8 inches of snow in a forecast, we'll make sure we have high reaches and equipment there to also aid in it before it opens. And then if any snowfall exceeds 6 inches, DRWC will ensure that the tent structure is re-inspected by an engineer before opening it to the public. So we were hoping to try to solve the tent issue with this protocol.
Debbie, did you receive this protocol? I don't see it in our packet at all. Or Phil?
Deb.
My apologies. I could re-email it. Would that be
it was sent. It's just one PDF. Everything's in there, Amy.
Under what title, do you know?
Can you read
It's-
the question, please?
It says DRWC River Rink tent letters to BBS combined. You're on the email
I believe
Okay.
these were sent this morning.
this afternoon. Yeah, it was
Yesterday.
sent. It was sent at like 12:21 p.m.
Oh, all right, that's why I didn't have it.
No, my apologies. We tried to upload it into Eclipse, but we were blocked out of Eclipse. It like the area to submit it into Eclipse was grayed out, and we couldn't. Ari wasn't able to upload it. I apologize.
Forward them again.
No,
Sometimes
I found it.
I have
sometimes
it.
it just does that, and it has no reason to do that, even if you should. So sometimes just like refreshing the page, it'll be good again.
My deepest apologies. Again, we didn't mean it to, have data come to you so last minute. Thank you for clearing that up, Matthew. It was like, what are we doing? What do we do?
I have the standard for operating procedure for snow events.
Yeah, I just
You
found
said-
it. Too.
You find it? I have it. 2.1 priority categories. Snow and ice removal operation will follow as prioritized, order based on operational safety considerations. Independent Blue Cross Rink Winterfest. The lodge tent, the skating rental, skating rink, and walking path. Cherry Street Pier, apron and garden. Vehicular access, Market Street, entrance, so forth and so on.
Yeah, the items that I referred to, sir, that I just sort of read out loud is also on the letter. We tried to summarize it in the letter. So if you look at the cover letter there under commitment to safety is basically those. We tried to summarize those key components that I just mentioned. But the SOP is standard across the organization so that it addresses all facilities. That's how they've been operating for the past couple 2 decades, I guess, ultimately, with modifications, of course.
And when is the I-95 cap intended to be completed?
So we understand it that it'll be completed in approximately 5 years. So what's happening is we're operating till we can get it moved up there. And, you know, at the end of Winterfest, you know, we shut it down and then it gets changed for Summerfest, which is much less stressful. You know, it doesn't have the snow events.
Matthew, did you review this?
Barely. I like just got it before the hearing started.
Okay.
So like I remember there was one thing that we did get some structural calculations last time. Remember there was one very glaring missing thing or something that was very glaring, which was despite this all these being up in the winter, it said like snow load and not applicable. And that stood out like a sore thumb.
Sure.
So I guess this is like the way the snow load is being taken care of by just making sure there is no snow. There will be no snow load, I guess.
Right, and that's what we're trying to handle it operationally. As you can imagine, tents like this are put up all the time by different institutions, colleges, whatever they may be. But you can't predict, like the next day they could have a major snow event or they could have a major rain event. We are trying to make sure that we manage it. Like we won't open the facility if it has a load. You know, we're creating those procedures to make sure that it's managed properly under Joe's, you know, that's why he wrote the letter and signed it.
Go to Joe Forkin?
Yes, sir.
Okay.
And I believe he may be here now. I'm not sure, but
I'm here. Yeah. Joe's here under the name Lizzie Woods. Joe and Lizzie here. We're both from DRWC. Sorry, it's just under my name.
Okay, can you bring your picture up?
Sure.
Okay. So you guys are gonna be testifying?
We can.
Okay, Joe, raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Lizzie, raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay, guys, tell us what you got.
I mean, if I could jump in and maybe summarize the letter for everyone that,
Yeah.
that we had written since it came so late, is that the rink's going on its 32nd season on the waterfront. And in previous years, other than this year, we had received temporary permits for the structures that are on site. And they were always tensile structures or tents that were there through the wintertime. And that's how we developed the standard operating procedures over time for the snow removal on the roofs. This year, we were asked to permit this as a more permanent facility or permanent structure, which dictated the need then for us to come to the Board of Building Standards to seek this appeal for this. And that's why we included.
Why was that done?
I'm not completely sure, Mr. Miller. It was just the L&I had decided that was the path that we should go down. So that's what we did. So I'm not positive as to the rationale as to why it was asked to be certified as a more permanent structure. But as Phil said, we expect the Penn's Landing Cap project and the Penn's Landing Park project to last about 4 years, 4 to 5. So we're seeking approval on this appeal for the 4 to 5 years. And knowing that we have these standard operating procedures in place, which have worked for 30 years, we're asking for the board to take that into consideration. I think the other point to raise is that one of the tents does have a snow load rating that maybe Art Miller can speak to, and both tents have that same rating. The one that stated it was not applicable, Matthew, was because we own that tent outright, and we have for a number of years. So I think that the tent company was not willing to provide the calculations for that, but they're identical tents in structure and form. And so they do have a snow load calculation already. And that coupled with the standard operating procedures that we have, we feel we've been very effective and incident free, thankfully, over the past 30 some years.
My question again, maybe it's to you, Matt, or somebody else. Why is it this year that they're coming in front of this board? They never came in front of this board in 30 years.
I think, Mr. Miller, I got a little light on it, which is that due to the construction of the Penn's Landing Cap project, the rink had to slide about 150 feet north. So the site is slightly changed from what it was before to make way for the construction laydown area. And that necessitated us to receive new permitting for the site and bring utilities to the site because it was sliding forward. So that was a whole new review by L&I And in that new review, because of the site moving, they had decided that we should go down this path for the structures.
Okay. And now the thing is that Matthew, what is the issue with this?
So the 2 refusal items on all 4 applications, I believe, they're all the same. It was it had to do with a geotechnical investigation report, as in one was just not provided despite the code requiring one. And then it had to do with foundations. Let me just go look at it again, what it says exactly. Oh, this takes forever.
I think that is correct. All 4 of them were for not having foundations and not having geotechnical reports. And we didn't have the geotechnical reports because none of them have foundations. So it's sort of like tied together, right?
Yeah, they're tied together, as in you can't have one without the other.
Right.
And the appeal is essentially that you have these anchorages that are sufficient.
Right.
What are they doing? Big blocks?
Let me go check what they are again.
Concrete blocks you have pictures of it?
Well, I think.
Yeah, it's big blocks, right?
But that looks like some over the top tie down at each end. But I think what we heard last time was that each of the columns for the tents will sit on a base plate that gets spiked into the ground through the asphalt.
Right.
My concern was
the asphalt.
Asphalt moves in the summer and in the winter. And has that had an issue at all? Because a slight movement of a structure can cause a lot of issues, a lot of extra stresses.
But just to answer that from experience, Ms. Rivera, it has not over the past 20-some years.
So this is the same design you used the whole time, essentially.
That is correct.
Now the strapping that you see with the concrete blocks is for the 2 sheds. That's and what we've provided there is the stamped engineering design criteria to show their abilities to be held down. Where they positioned on the site, the uplift, it really isn't even that difficult because they're kind of surrounded by a number of different things.
So our issue, aim, is the only thing is that we were worried about the asphalt with the stakes going in it?
Yes, and we were worried about the snow too. The one set of wind calculations is not stamped at all from Gray Fox, which that really should be.
So if there's a missing stamp, we can get it. If you see the, I mean, I can show it on my screen if, well, I don't think I have the ability to share screen, but.
You do.
Yeah, sure.
Where do I? Oh, here it is. Sorry. Okay. Does everyone see this?
No, doesn't look like
not yet.
Not yet. It's coming up.
Now?
Yeah, now we're good.
Got it.
Okay, so this was our attempted solution to make everyone comfortable from the last meeting by putting in the concrete barriers and then having the strapping system hold the tents down. And what we've shown is that I think in the design criteria, our engineer here, Childs Engineering, has attempted to show the evidence that it also handles the lateral slide. So, and again, it's the period of time necessary. Like we can also, if there's 100-mile-an-hour windstorm, we can close the facility as well so that nobody's in there. But Childs Engineering has provided their data. If there's a missing stamp, we can reach back and get it stamped and put it into Eclipse at any time you will allow us to do so. We can, probably even do it this afternoon or tonight if necessary.
Have these barriers always been present?
No, this is our solution to try to solve your concerns from the last meeting.
This is the sheds, not the tents. We switched gears here.
Yeah.
Okay. My concern was really the asphalt moving, because asphalt buckles. It can heave in the winter and it can really buckle in the summer. That was my concern. I don't know that adding heavy weights on top of asphalt is what I was expecting, but. Wayne, can we caucus?
Sure, sure. Okay. Let's see here.
Well, is everybody back?
I'll be here in a second, hold on.
Oh, sorry about that.
That's okay. All right, we, after talking, we're gonna, grant the variance, okay?
Thank you so much. It's
Okay.
very kind of you. We really appreciate it.
All right, guys.
For all
Good
four?
luck and just,
Is it good?
For
Is
all
it good
four.
for all four?
Okay, just checking.
yes, yes, yeah. Make sure you follow that, the SOPs and check it with all that stuff. I don't know if you have drills or anything like that, if you let the people know if there's snow loads or anything coming. Please,
And any provisos? Sorry.
No provisos.
Okay.
all right, guys, good luck.
Thank you
Thank
so
you.
much, everybody.
Thank you very much.
All right,
Have a wonderful week.
I'm gonna try. We'll see you tonight.
Thank you.
All right.
Bye.
We did not read the three remaining cases in for 1 South Christopher Columbus. Should I read them into you one at a time, and you can just give me the vote that you've done for each one? Would that work, Ryan?
Yes, that'd be
Yes,
good.
that's fine.
That's
Okay.
perfect.
MI
Good job,
2024-007-147 for the property 1 South Christopher Columbus Boulevard.
Okay, we're good with it. Aim,
Grant variance.
okay, grant the variance, Ted,
Okay,
Will do.
okay, go ahead,
Next.
Phil.
MI
We're ready.
2024-007-148 1 South Christopher Columbus Boulevard.
Okay, are we good with the variance, Aim?
Grant variance.
Ted,
grant variance.
I'm me too, I'm in with it, fine.
Okay.
Next one.
MI 2025-000048 1 South Christopher Columbus Boulevard.
Grant variance.
Grant variance,
Grant variance.
okay, we're good.
And
Next one.
lastly, MI 2025-000049 1 South Christopher Columbus Boulevard.
Okey dokey,
Grant
grant
variance.
variance,
Grant variance.
okay, all right, next case.
Next case is 1524 East Passyunk Avenue, and the appellant is present in the room.
Okay, 1524 East Passyunk. All right, let's see here. Okay, who's here from Passyunk?
Good afternoon. My name is Lee Elsey. I'm here, and we also have the owner, Mr. John Galati, is present as well.
Okay, Lee, are you a lawyer?
Not in this matter.
Oh, okay, all right. Could you please raise your right hand, swear to tell the truth, nothing but the truth?
I do.
Okay, John, could you please, you're gonna be testifying?
If I need to.
Okay, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
This is
Okay,
the
is that?
reporter, pardon me, this is the reporter. May I please have John's last name?
Galati, Galati.
Okay, John?
Yes, thank you.
Okay, is there anybody else? It's just you two guys?
Should be, yes.
Okay, all right, we'll get started. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Agus, board member.
John Dimes, Fire Code.
Ryan McSherry, board counsel.
I'm Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Bill, could you read that into the record, pal?
Yes, sir. This is MI 2024-007466. The property is 1524 East Passyunk. Lee Elsey is the appellant. He's present in the room, sir.
Okay, Lee, you wanna present the case?
Certainly. I'm going to share screen real quick.
Absolutely.
We'll make it easier to understand.
We got it, their pictures are up.
Okay. What you're looking at right now is a sort of zoom in on the approved zoning application. Just to clarify, this is at 1524 East Passyunk. It's in a CMX 2.5 zoning district, which allows for buildings with a maximum height of 45 feet. Just to zoom in on the building section here, there was an existing 2-story structure. And what we applied for was a by right zoning solution to increase the building to 4 stories, which takes us to 42 feet of building height. We are seeking, now this was always there was always a residential in the building. We're seeking for 3 residential units with a commercial space on the ground floor. We received a zoning refusal related to having R2 use on the 4th story with a single stairway exit. The way we designed this addition to an existing building, in order to minimize the impact of using the 4th story, which is sort of an element of this zoning district, was to treat the uppermost unit as a bi-level unit. So this is the plan of the 3rd floor. There's a common stairway that comes directly, an entrance directly from East Passyunk, which travels up to a unit on the 2nd floor. Gives you an entry, a common entry into a unit that's on the 3rd floor, and then gives you an entry from the 3rd floor to a bi-level unit that is primarily located on the 4th floor. That was our attempt to provide a bi-level unit that's on the 3rd and 4th floor, that allows us for an internal unit with an exit into a rated common stairway on the 3rd floor that gets you a direct and straight shot out into the public right of way. Our travel distance, there is a roof deck that's solely dedicated to the uppermost unit. The total travel distance from the farthest point on that roof deck down the stairs and to the rated exit on the 3rd floor is 106 foot 8 inches, which is within the permitted travel distance. So we're seeking relief in this matter in order to have this configuration. The building is fully sprinkled with an NFPA 13 sprinkler system throughout. We have a 3-story connected stair shaft, which is currently showing a 1-hour rated shaft wall, which is what the code requires, but we're also willing to upgrade that to a 2-hour rating.
Finished, Lee?
Yes, I'm happy to open it up to discussion.
Okay, all right. Anybody have any questions?
Yeah, Matthew Wojcik. It still is a 4th floor, correct? Which would require a second means of egress. And,
yeah, it needs.
And the same with
the story has to have 2 exits or access to 2 exits.
And the roof deck also?
Let me just double check exactly what the section says. Okay, any story or occupied roof.
Okay.
What does that mean?
They both need a second means of egress.
So the slight correction. So the roof deck, so part of the single exit section has a thing that says individual single or multi-story dwelling units can have a single exit or access to a single exit, provided that both of the following criteria are met. One, that the travel distance to that exit is less than 125 feet or up to 125 feet. and that when you leave that dwelling unit, you then have access to 2 exits.
So just to clarify on what Matthew's saying, if there was a way to have an exit, if our stairway came down and gave you an exit on the front and there was also sort of an exit to the back, this configuration would be permitted with the entry on the 3rd floor. It's purely because we don't have a way to get a second exit off the 1st story, or well, it would have to be on the 1st story, right? Right, Matthew?
I mean, as in once, would have to be like, once you like exit the dwelling unit that you currently enter through the 3rd story up to the 4th story and the roof deck. Is that like once you leave that dwelling unit, you would then have access to 2 like independent exits. So like it's like it opens like into a corridor that you could then choose between one exit or the other.
Now, this is kind of a common building type that, that we have throughout Philadelphia, that after, the change to the 2018 code has been, has been more and more difficult to pull off. We would also plan to provide sort of the ladder escape boxes at the bedrooms on each unit, at least in the 4th and 3rd floor. I mean, that's another thing that we'd like to incorporate.
What does your rear yard look like? Are you landlocked back there, or do you have an alley access?
We have an alley, and we did consider, sorry, I think it's easier on the zoning. We have 15 feet. Now, the tricky thing with having a second exit off the rear, kind of if it was fully existing, we could do a fire escape. Because of the amount of addition, any fire escape would have to have a 10-foot clearance from all property lines. That's correct, right, Matthew?
That's if it's an exterior exit stairway. A fire escape built to, it's in the IBC, like it's like chapter 8. One of the sections on it has all the rules on what a fire escape consists of, but the fire escape doesn't have that 10-foot in all directions rule that the exterior exit stairway has.
So Matthew, if there was an exterior stair back there, could it be at the 3rd floor level, or does it have to also access the 4th floor and the roof
It
deck?
could just be for that specific unit, because all the other units can have access to one exit.
Right, but would it only need to hit the 3rd floor, or would it need to hit the 3rd and 4th floor?
Okay, so interesting. So because that roof deck is exclusive only to that dwelling unit, as long as that dwelling unit complies with the rule I said before, which is that it has a maximum travel distance of 125 feet to the unit and to like the unit entry door. And then as long as someone like leaving that unit has access to 2 exits, because it says that either the exit from the dwelling unit discharges directly to the exterior, or the exit access outside the dwelling unit's entrance provides access to not less than 2 approved independent exits. So an exterior exit stairway complying with that specific section in the IBC, that would not necessarily have to hit all those floors, and neither would a fire escape. The main difference between that and a fire escape that complies with the rules, and I'm just trying to pull up the section in the IABC. Let me find it.
Would the IABC apply to this unit?
Oh, because it's an addition.
But isn't
Let me
it a
double check.
4-story?
Let me see exactly what it says.
Matthew, isn't it a 4-story building, so the IBC does apply?
Yeah, it does.
So IBC, I mean, the existing building code has provisions for fire escapes.
Yeah.
I'm not aware that the plain IBC for new construction does.
I see what you mean.
Our hope, our sort of our the intent of what we've done, from that third story exit, it's a 50-foot shot straight down a stair to the public right of way with a 2-hour fire protection and full sprinklers. We're hoping that that satisfies the intent of the code to give a safe way to egress from this unit.
Just a couple of questions to Matt.
Yeah.
Are you suggesting that if there were a exterior fire stair, and that we were comfortable with not requiring the 10-foot setback and so on, that they would only need to access that at one of either the third, the fourth, or the roof deck level to be compliant?
I mean, really the fourth story, since that's where most of the unit is.
Right, but technically it could be at any of those places, or?
Yeah, as long as the fourth. So for fire escapes, the main difference between the fire escape and the exterior exit stairway is that the fire escape doesn't have to be like accessed from like a corridor that's common to all the other dwelling units. It could just be accessed from the dwelling unit.
Right.
The fire escape is also a much it allows you for a much steeper riser height, and it's also like 20 feet, right? Sorry, 20 inches of width or something like that.
Yes.
Whereas an exterior exit stair would be a full
it's a stair.
3-foot
Well,
stair.
what I'm thinking is you have a 5-foot side yard. We might consider a spiral stair in that 5-foot side yard to get you out from the third floor. But
well, from the fourth floor, since most of the unit in question at the fourth story is at the fourth story. So.
Okay.
Because the unit that's contained entirely within the third story, unit 2, that could just have access to the one exit and it's fine.
And Matt, is a fire escape permitted? It's permitted in a renovation, but not new construction. Is that correct?
Right. It's not allowed in new construction, but what the IEBC says is for other than Group R2, where more than one exit is required, an existing or new constructed fire escape complying with the rest of the section shall be accepted as providing one of the required means of egress.
Okay, so the fact that this unit is entirely new construction, it's still considered a renovation addition.
Yeah, it's an addition.
Okay.
Because there's nothing in Chapter 11 of the IEBC that would preclude a fire escape from being installed onto like the new portion of a building.
So Amy, what you're suggesting is if there was access to a stair in that side yard, if you will, I mean,
at this location.
Yeah, I mean, that would be where there's a bedroom. I mean, you'd end up having to go.
We'd have to, we would shift any other windows.
Gotcha. Okay.
Clear that, and then that would have to run straight down.
Yeah. Yeah, I mean, I think we understand what you're saying in terms of the straight shot out and, down and out, but I think where it's been physically possible to do it, we have typically required either an exterior fire stair or a fire escape in order to provide the second exit.
Yeah, I didn't, when this was called a bi-level, I thought most of the third floor was part of this unit, but it's really only a little bit of a corridor. So you're right, it would need to go to the fourth floor.
Yep.
I barely refer to this as a bi-level.
Yeah.
Are we good with that?
I'd like to see a spiral stair off the fourth floor.
John, is that acceptable to you?
I mean, Amy, when you're saying spiral stair, I mean, it doesn't necessarily need to be a spiral stair, does it? Or
a non-combustible stair will allow it to be within 10 feet of the property line. But, and I would be willing to give a 5-foot spiral to fit into that little side yard to keep the backyard open.
Got it.
I think that would be an acceptable solution.
Ed, are you good with that?
Yeah, I am. John, do you have any,
No, I'm good with that.
John Dimes.
No,
John
Dimes.
Dimes,
Another
thanks.
John.
Yeah,
sorry.
no, that's all right.
Never Dimes.
Yeah, hey, how's it going, Mike? Who's flying that drone over your head, by the way? But no, I'm good with that. It sounds like it's allowable by code. So once he does that, it's by right. He's complying with the code, and no variance really needed. Is that accurate?
I mean, making it a spiral staircase, since that wouldn't be strictly in compliance with the fire escape rules. Because I believe fire escape, you're not allowed to like have a fire escape as a means of egress. So like using this, so like having a fire escape or having like a fire escape in the shape of a spiral staircase.
It's not.
I guess that would have to be the variance.
I'm okay with it. Second way out, upper floor. Yep.
And to be within 10 feet of the property line.
Correct. Yeah.
Yeah.
Everybody good with that?
Yes. I mean, the other thing to note, I mean, while, it'd be great if you had the 2-hour, separation you were calling for, you wouldn't be required to do that, as long as you're providing the second exit.
And also, we would want a sprinkler head at any window that this new external stair is going to pass.
Yeah.
Oh, yeah.
We'll pull the rest of the windows off the line of that stair, and we can also put the additional head on as well if that's.
Okay, everything good with that?
Yep.
All right. Good luck, guys.
Thank you.
Okay, you're welcome.
Thank you, Jim. Thank you.
All right. Okay. What do we have here? Federal Street? Next one?
Yes, sir.
Okay, who's here from Federal Street?
I am.
Okay, is that Devin?
Yep, Devin. Okay, yes, sir.
Devin, are you gonna be the only guy testifying here today?
I have the contractor on, but I'm fine to go through it. I'm the attorney for the project.
Are you, okay, so, all right, I don't have to swear you in. Is the owner of the project gonna be testifying?
No, he isn't.
Okay, it's just gonna be you?
Yes, sir.
Okay, all right, we'll get started. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Ogden, board member.
John Dimes, fire code.
Ryan McSherry, board counsel.
Matthew Wojcik, LNI supervisor.
Philip Motto, boards administration.
Okay, Phil, could you read that into the record, please?
Yes, sir. This is MI 2024-007-467 for the property located at 1307 Federal Street. Devin Yukta Esquire is the appellant. I apologize if I mispronounced your name, sir.
No problem.
Okay, all right, Devin, you want to present the case?
Yeah, sure. Can I share my screen?
Absolutely.
Let me know. Can you see this presentation?
Not yet, but it's coming up. There we go.
Okay,
There we
we're
go.
good.
All right. So I guess just a high level overview of what's going on with this property. This is a property that my clients owned since 2000. And I looked at the permit records. It hasn't been much renovation from 2000. It's always been a multifamily home, and it was built, the record shows built in 1915. So more recently, they were issued a notice of permit refusal. So what the client is attempting to do now is it's a multifamily property. The bottom unit, they're looking to basically shore up and expand a little bit. So basically going to shore up the back wall and push it back a little bit to the bottom unit. So right now it has 4 units. So this is basically just the bottom unit is 1 unit itself. They received the notice of refusal for 2 things. One of the code violations says that they're actually in conjunction with each other, the fire protection system and then the group R. So pretty much what is happening is group R is dwelling units that are over 2 units or more, and then the fire protection system basically establishes that they need to have a sprinkler system if the dwelling unit has more than 2 units. Now, a review of the code it says that pretty much with the sprinkling systems, you would need that if you had constructed the property after, I believe it's 1984. This property's been constructed since it was constructed in 1915. And I have some pictures of the prop. So again, this is the properties that are owners. This property was purchased, as I said, in the year 2000, and the year built was 1915. A review of the record showed there's been no major renovations or permits pulled on the building. For the most part, it's just been kept in the same condition. So the current property is the property from the outside. The current property was in compliance or is in compliance because based on the code, if you do not have the sprinklers when it was originally built, because it was built prior to 1984, you could have the smoke detectors and fire alarms that are interconnected into the building. So what the client has, these are pictures of the smoke detectors that are basically connected all throughout the building, smoke detectors and fire alarms all throughout the building, as you can see, that are just hardwired into the entire building. And what we're hoping to do is, and then here's a picture of the drawing in the back of the building. What we're hoping to do is to get an exception to this requirement to install the sprinkler systems at this point, because the cost to actually do that to the building would be extremely burdensome on a property owner. On top of the fact that the property owner actually complied with the code by having the smoke alarms and the fire alarms hardwired into the building, which would be an exception to the code because the property was constructed prior to the 1984 date.
And was this all triggered because of an illegal addition that happened?
So it's not an illegal addition. It was triggered because of them basically doing the back wall. Because it's not an addition. They're not adding another unit to the property.
Not adding another unit, but it looks like another room was added. There's outstanding violations back to 23.
So so it was triggered because of the construction, yes. Okay. There's not another room being added. It's the wall it's like the back wall that they're shoring up. They're not adding another bedroom though.
I don't have plans to understand it. I saw your plans quickly. Do you have photos of the back of what was done?
Of what the back of the unit, what was like you mean outside of plans, like physical photos of it?
Physical photos.
No, I do not have those in this presentation now.
So can you zoom in on that section on the bottom of the sheet?
Yeah, sure. Wait, sorry.
All right, it says Unit 1 addition on the left side of that plan, but you're saying it's not a room addition.
No. So I've actually walked the property. The bedroom spacing thing that has not actually changed.
Can you show me the section that is underneath that first floor plan?
Show you the section.
Just scroll down to the picture in the box underneath that. So it's showing a new roof and new walls, but you're saying that's not an addition and a new existing slab.
So what I'm saying is that so where the property is, there's a wall that was not like sturdy, for example, tore the wall down and building back up. And building back up, they are putting like more roof heading because it comes out a bit. But it's not like, I guess, it's not an additional room. Like it's not that large, is what I'm saying.
It doesn't matter if it's not that large. If it's an addition with a roof and walls, it's an addition. I mean, there's a new foundation wall there. So it implies that it's a wall where there was never a wall before.
You go back up to the plan on the left, where it says, unit 1 addition. I mean, that's a new. I mean, Matt, is there a size of a room that triggers being considered an addition, or is that?
No, for group R in particular, the requirement is this. So the requirement in the existing building code is just existing fire areas that are existing fire areas increased by the addition shall comply with Chapter 9 of the IBC, and then going to Chapter 9 in the IBC for Group R, it just says it says buildings with a Group R fire area shall have sprinklers installed throughout. So from there, it's like by expanding the Group R2 fire area, sprinklers are like required. And then whether or not it's throughout the whole building or throughout just the addition or throughout just that unit, at that point it becomes vague. And the commentary actually mentions that, yes, they acknowledge that it is vague from that point forward. So at that point, it's a matter of like fire ratings and, like fire ratings to contain the fire area. Yeah.
And does the age of the building come into play?
There's there's no sections that like talk about age in the existing or in the existing building code or in the existing building code or just the building code. If you're talking about like fire code stuff, then that is for when the building is just like existing just as is and there's no work being done to it. But in this case, work is being done, so the building codes apply as opposed to the fire code.
So based on that commentary, at the minimum, the small addition would need to be sprinklered.
It could. It could if you contain
request that or not.
Sorry.
Yeah, go ahead.
So if you contain the new Group R fire area to just that addition, then you could just have sprinklers installed in that addition. It's just a matter of whether or not that's like practical to achieve.
Right, slide back over so we see that in plan again. Just
slide to the left.
Yeah, thanks.
Just want to tell me when to stop.
Keep going. I'm so we
just more
addition. Yeah,
there we go. Right here.
Okay. So right now there's an opening there without a door in it, but that's an existing brick wall. So Matt, you're saying if that was, let's say, a rated door on there, would that be considered a separate fire area?
If that rear wall had a 2-hour rating and the door had an exterior door, I believe, would just need to have a 90-minute rating if it's within a 2-hour rated fire barrier. Well, exterior wall, then that would be sufficiently separated because there's nothing above that addition, as far as I know. So the roof wouldn't have to have that fire rating. The 2 exterior walls of it and its own like rear exterior wall would only have to have a fire rating based on what's required by the construction type and the fire separation distance.
So the only change to the existing building is this small addition.
Just some interior renovation, but that in of itself would not have triggered the refusal.
Oh. So what did? Sorry.
Just the addition. Just the addition is what triggered the sprinkler requirement. That's it.
Yeah. And again, just so when we're saying the addition, this, whatever it is, no, I can't quite read that, 6 foot by, whatever.
It's small.
Well,
Yeah.
6 foot by.
It's real
let's
small.
see, 6, 9, 10 foot.
Hmm?
I mean, arguably, it doesn't increase the risk level to the building.
That's up to the board.
Right.
I know.
And is this just a one-story addition?
Yes.
Yes.
Okay.
Do we want a caucus or do we want
Yeah, let's caucus.
John to say anything or?
Not
John?
whatever you guys decide.
Okay, pal.
All right.
Okay, we're gonna grant the variance, because it's so minute, it's not actually a major addition, but I hope you take from this, we could have made you sprinkle that. If there's anything you do, again, please go through the process, and, be aware what the things can happen. So, but because this is so small, we're gonna give the variance, okay?
Thank you. I appreciate it.
All right, guys.
I want to see if we could just take a very brief 5-minute break.
Sure.
Sure, yeah, that's good, yeah, I agree with that. North Third Street? Okay. Who's here from, 151 North Third Street?
Hi, everybody. My name is Gabe Deck with Gnome Architects. Happy New Year.
Okay, Gabe, you gonna be the only guy here
Yes,
testifying?
I am.
Okay, let me swear you in. Please raise your right hand, swear to tell the truth, whole truth, nothing but the truth.
I do.
Okay, good. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
John Dimes, Fire Code.
Ryan McSherry, board counsel.
And Matthew Wojcik, L&I supervisor.
Philip Motto, Boards Administration.
Phil, could you read that into the record, please?
This is MI 2024-007-525 for the property 151 North 3rd Street, parcel B. Gabriel Deck is the appellant. He's present in the room, sir.
Okay, Gabe, you wanna present the case?
Sure thing. I'll share my screen. All right, see my screen?
Yes.
Okay, so this project consists of an 11-unit residential building. We were actually here once before for another matter, so you might remember it, but this is at 151 North 3rd. Actually fronts along Quarry Street, which is a smaller side street around the corner from 3rd and Cherry. So it is a 6-story building, podium construction. We have type 1A concrete construction up into the 2nd floor deck, and then it's 5 stories of 3B construction above. So this is kind of the front elevation. This is kind of the rear. We have an exterior staircase. If you recall, that's what we had come to you guys before. It's a very tight site, challenging site. And which is why we've had some of the arrangements we've had. Just to remind you of kind of the configuration, this building also has underground parking below the concrete podium. On the left-hand side is the 1st floor arrangement, kind of showing the constraints of the parking on the far right side coming into the building into a ramp, and then the access alleyway on the far left side where the building entrance is. We have a interior stair tower at the front left, bottom left corner, and then an exterior stair tower at the top left. So we essentially have 2 units per floor across 6 floors, with the exception of the 4th floor, which is just 1 unit. Up at the 5th floor, this is essentially the configuration. Figure I'd show you the color-coded version just to kind of help you understand, but we have 2 units, one facing the front, one facing the back, and then the egress components are on the far left side. So we have 2 stairways, an elevator, and then a corridor connecting things. What we were looking to do was to introduce a horizontal exit at the 5th and 6th floors, which would separate the building into two zones. Here is our life safety plan of the 5th floor. I've highlighted in red a 2-hour horizontal exit component that cuts through the building. We're required to provide remoteness of the exit stairways, and then also a remoteness measurement between the stair tower and the horizontal exit door that's within the corridor. Other requirements when putting this in, we're required to have 1 or 2-hour rated walls that cut the building in half, and then we also have a 2-hour separation above and below on each level. So the entire 5th floor deck is 2-hour rated from the floors below, and then at the 5th floor ceiling, which is the 6th floor, it's also 2-hour rated to satisfy creating this horizontal exit. Where we have an issue is simply the remoteness now measured between the door of the stairwell and the door within the corridor. Without the horizontal exit component, we are permitted to measure remoteness by way of a walking path rather than a straight line, which I've kind of illustrated a walking path. And I've color coded kind of like the measurements that we have from a diagonal standpoint and a walking path standpoint, just to kind of demonstrate, where we're trying to meet the spirit of the code. But long story short, yeah, we're here because just the remoteness measurement between the stair tower door and the horizontal exit is short of the required remoteness, which is 31'6". From a diagonal standpoint, on the longer side, we are at 23'5", so 8 feet short. And then on the shorter side, we're at 13 feet, so about 18 feet short. We still meet the area of refuge that would satisfy the occupants of the floor. And then we also do meet remoteness within the longer measurement. In green does meet remoteness if it were to be measured along a walking path, which you can do without the horizontal exit. What we're proposing to do to ensure the life safety of the building is still adequate, we are proposing to up the rating, the required 1-hour rating, which is currently the interior wall that separates the corridor from the units is required to be 1-hour rated. Typically, we're proposing to up that to 2 hours at the 5th and 6th floor where the horizontal exit component is. And in addition to that, rating all of the bearing walls that support the structure, the 2-hour rated structure, as 2-hour rated walls carrying all the way through the building. And it's of our opinion that this is in the spirit of the code, and we're essentially doubling the rating requirement within these corridors that become the refuge areas, 100% above and beyond what they normally would need to be required. That's pretty much the gist of it.
Anyone have any questions?
No, just Matthew Wojcik is. So based on what they're doing, is the only issue then the exit remoteness?
Yes, the main issue has to do with how the code allows you to measure along the actual path of egress in a corridor, but it does not say it does not mention anything about measuring to a horizontal exit. So that little exception can't be applied here because it doesn't allow you to measure along the actual path of egress to a horizontal exit.
Are the sprinklers NFPA 13 or 13R?
I mean, it has to be 13. It's a 6-story building.
Okay, got it.
Is this the same issue with the other?
The other.
Parcel B?
Let me double check. I think they're different issues.
Okay.
I believe so.
Yeah, and I can't speak to the other parcel. We're not the design team on that one.
Yeah, it's a different applicant, different everything.
Okay.
It's Mark, the next guy.
I'm okay with this.
Yeah, I'm okay with it. Yeah.
All right, I'm fine with it. No
I
problem.
think it's responsible.
Okay.
All right, good luck, guys. Okay.
So wait, this is not what was submitted, correct? Or is this what was submitted?
This is what was submitted. However, it doesn't yet show the proposed 2-hour corridor walls that we are, you know,
That you offered.
that we're offering. Yes.
Okay. That will be your part of there.
Good luck, Gabe.
So, yeah, so we'll list those as a proviso, yeah.
All right,
Thank you so much.
no problem. Okay, next case.
I think that's
No, we have
that
one
it?
more. The
Yep.
appellant is
Oh.
Mr. Mark Wallace.
Mark
I believe
Wallace?
He's here in the room.
Yes. Uh-huh.
Hello, General. Hello, Board. I'm sitting.
Yeah, Mark, over there, okay. Mark, you're gonna be testifying?
Yes, sir.
Okay, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Anybody else gonna be testifying?
Yes.
Logan?
Yes.
Okay, state your name.
Logan Kramer?
Okay, you swear to tell the truth, the whole truth, nothing but the truth?
Absolutely.
Okay, is there anyone else testifying? Just you two guys? Okay, my name is Wayne Miller, board member.
Amy Rivera, board member.
Ed Agus, board member.
John Dimes, Fire Code.
Ryan McSherry, board counsel.
I'm Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Okay, Phil, could you read that into the record, please?
Yes, sir. This is MI 2025-000154 for the property located at 151 North 3rd Street, Parcel A. Mark Wallace is the appellant. He's present in the room, sir.
Okay, whoever's gonna present the case, go ahead.
Yes, so approximately a year ago, we came before the board. We have an existing 5-story historically registered building that currently is a retail storage and office use throughout. We are looking to keep a commercial unit at the 1st floor and then 3 apartments at the 4th or 2nd through 5th floor. The top unit, the 4th and 5th floor, is 1 bi-level unit. So it's 2 flats, 1 at the 2nd, 1 at the 3rd, and 2 at the 4th and 5th. When we appeared before the board previously, we presented the existing stair tower to remain in there, to add a non-combustible exterior fire escape to the rear. Since then, we've upgraded or per our previous conversation, we upgraded the existing stair, which was non-code conforming, to a fully conforming IBC stair tower with the rise run, the proper fire separation, and all clearances. In doing so, we're moved through the construction documents, and when we got to the bidding process, the fire escape on the rear ended up coming back significantly higher than we expected. With that, I would like to turn it over to Logan to present the financial portion on what we are struggling with.
Thank you. Appreciate it. So let me screen share here. All right, can you guys see my screen?
Coming up. There you go.
All right, cool. All right. So this is the rendering for our project here. So yeah, as Mark stated, our building is a 5-story historical building. It's being converted. Its original use was office and commercial and retail for all 5 floors. We're converting it to just 1st floor, ground floor commercial. There's gonna be tenant storage in the basement. And then there's going to be 1 condo on the 2nd floor, 1 condo on the 3rd floor, and then a condo on the 4th and 5th floor, which I'll be living in myself. That being said, we're going to be bringing down the use category of the building, so it's going to be a way less intensive use from going from 100% commercial to only 1 floor basically of commercial. As we mentioned, while I am an experienced developer, I've never installed a fire escape before, and I kind of learned the hard way on this one. When we were at the board a year ago, we were asking for a fire escape to be approved in the rear of this. My expectation was this would cost like something to the tune of like
I don't know, 30 grand, 40 grand, something that it was unfortunate for the project, but it wasn't going to like bankrupt the project. That being said, we accepted the variance at that time, did not have any bids in hand. About 3 months afterwards, we got our construction documents, got our first bid, came in crazy high, and I thought it was a mistake. It was the one bid we had of 208,650, and I was like, there's got to be a mistake. I call my steel guy and I go, what's going on? And he's like, yeah, he's like, this is the cost for what it is. I was like, why is it so expensive? He's like, this is the cost. I was like, wow, this is blew me away. I then sent this to 2 other fabricators. And I even tried value engineering the design with them multiple times, but effectively it's it's got freestand, or it's not freestanding, it's got supports in the ground. And it being basically it's 5 stories plus the roof access at 6. So it's a kind of monstrosity of a fire escape. And to kind of explain what the benefit of this is it's strictly only kind of giving egress to one unit that is required from a code perspective. It's just the 4th floor, 5th floor unit that is requiring the necessity for this exterior staircase, which also I'll be living in myself. So it's $180,000 of cost for one unit, which like just as a developer, like typically I see like life safety as like a per unit cost of like 10, 15, maybe $20,000 per unit on like a per unit cost. And on top of that, it's just put our completely project in jeopardy. We're at a standstill. The building also is kind of like in an exposed condition, where like it's like we did the interior demolition before we discovered this cost. It's structurally all shored up and whatnot at the moment. It's not like in a dangerous condition in terms of where it's at. But what I will say is that like if the project just kind of sits like this, it's a 200-year-old building that will over time just kind of decay and not like in being in like a structurally safe but like shell condition. We at our BBS hearing, we agreed to changing from an NFP 13R to an NFP 13 and boosting the sprinkler system. Another big cost in this, like I'm used to sprinklers costing me about like $15,000 per unit at most, but this is a very small building that needed a booster pump and a standpipe, which a booster pump and a standpipe on a 15 or 20 or 30 unit building is not a crazy cost, but that on basically a 3-unit building is a massive expense. Like our overall sprinkler cost that we're spending here is like over $140,000. As I mentioned, like just our overall life safety budget on this project between the sprinkler system, the fire escape is, just putting the property at, like a verge of bankruptcy. And we're doing a lot on our end of like reducing the occupancy from commercial to residential. We did a lot with kind of the original BBS of I think there was like I don't have it in front of me, but I think we agreed to like 2-hour fire ratings, horns and strobes, and improved sprinkler system. And then on top of that, the building's historic, which also has like about $120,000 of historical facade and structural retrofitting costs that we've kind of had to burden, and like our project performance just kind of like upside down on this. The proposed life safety features that we're proposing would be 2-hour fire rating between units when only one would be required. That was something we agreed to a year ago, that we definitely want to keep that and maintain that. The providing the horn and strobe fire enunciation throughout, keeping and maintaining that. The much more expensive NFP 13 fire suppression system instead of NFP 13R, we'd be keeping that. We removed the old stair tower in the building, and we're putting a new stair tower in the building that does meet code and it's code compliant. And then as additional measures, we're happy to put as many like handheld fire extinguishers throughout the building. Not just instead of like 1 per unit, like if you want 3 per unit or 3 per floor, or whatever things we can do to get everyone to, feel happy and, about, down life safety we're putting in the building and, as a good compromise here. If you want, the ladders that you can put out the window, whatever you want, that's kind of more reasonable things that aren't going to cost basically like $180,000 to achieve a similar degree of safety. Like we're all open to ideas, but we, like feasibility wise, just the project is completely unfeasible. And as I showed here, like we're, just at kind of the start of this project, and like we're projected to make like a loss of 166,000. And if I wasn't going to be occupying the upper unit, honestly, I wouldn't be going through with this project, and I'm just gonna like leave it as is. It's really unfortunate where we're at with it, and I definitely just kind of coming for to with a bunch of compromises, and definitely want to kind of work something out that from a life safety aspect checks everyone's boxes and everyone feels good about it. And I think just to kind of go back on the fact that like the $180,000 cost is only helping one unit in the building. And if you want me to sign something saying that I'll live there for a long time or anything like that, like I'm happy to sign whatever. Like it's my full intention to live there for somewhere like 5 to 10 years. So but yeah, it's kind of where I'm at overall with the project and presentation. Definitely open to any fresh ideas that I've not brought up for life safety that would kind of be a good middle ground that would get us back up and running.
Can we see your plans?
Sure.
Absolutely.
Okay, so along the margin to the right-hand side is 3rd Street. And then along the rear of the building is where the stair tower was supposed to be, or was originally in our previous design. So we have at the 1st floor, which is this plan here, we have the commercial unit that fronts onto 3rd Street. Our main residential entrance comes from a shared easement with the previous project that you heard, coming down through the rear of the project into a lobby, a 2-hour rated stair tower that goes up to the 4th floor. And then in the 4th floor, there's in the 4th floor, there is a stair within that unit that takes you then up to the 5th floor, and then one above that, a roof access well that takes you up to the roof deck that appears in the rear of the project.
How much of a rear yard is there?
6'6". And then it widens once it gets past our property to like 10 feet as it extends towards the right of way on Quarry Street.
And do you have a picture of what you had priced, the stairs you had priced?
Yes, give me 1 second. I can bring up the old drawing.
Was it priced as a exterior non-combustible fire stair as opposed to the fire escape?
Yes.
I had this thing priced 50 different ways because when I first got the price, I was just kind of give you background. I've built over 400 units. I've most times when I'm doing things, it's a 2-staircase building, and it's also 30 units, 40 units, 50 units. I've never had a 5-story building that is this small of a floor plate. Like my 5-story buildings are like 10,000 square foot minimum footprint on the floor plate. So it's a 50,000 square foot building. So I haven't run into things like this before. And it was my first time, very painful exercise to say the least.
Had you looked at a spiral staircase?
We did look at one. It was something that we proposed to the board, and the board said no, but I also went back to when a year ago you said no to that. And I went back to my fabricators, and effectively the big cost to this is that once you're above like a 3-story fire escape, it becomes like the level of structural steel that this takes is like where it becomes extremely, extremely expensive. And like me doing this as a spiral staircase, outside of it being, you know, it would get us, you know, some small savings. Like they said we'd be at like 130 or 140,000, but it's still, like I mentioned, that's a massive cost just for one unit to have benefit of it. It's not like it's you know, 130,000 I can amortize over 20 units or something like that.
Matthew Wojcik,
Yeah.
second set of stairs would be required from which level? Starting at 4
The
or starting
fourth.
at 3? Okay.
Starting at the 4th and 5th.
Fourth, yeah, the 4th and 5th floor.
The 3rd and down, it's fine.
Okay.
And just to kind of add as a hardship aspect, like I didn't build this building. This is from 1825. You know, modern day, you don't build a 5-story building with an 1,800 square foot, or sorry, 1,400 square foot footprint, because of exactly this reason. And this building was originally designed with one staircase in it, because that's kind of what fits for a 1,400 square foot footprint.
And Matt, again, just to clarify, the stair was an earlier case with where either the 3rd floor, 4th floor, or roof, an exit was required from one of those in that sort of bi-level unit. Is that similar here, or is?
Yes, this is like, I guess you could say this is even more clear of that, like it does need it because the interior exit stairway goes right up to the 4th floor, and that is the only exit that unit currently has, and that also is a bi-level unit, like very much actually a bi-level unit at this time because it is entirely contained within the 4th and 5th floor.
4th and 5th floor.
Yeah.
Also,
the
if it
5th
was
floor,
if we had a building large enough that we could get 2 means of egress just up to the 4th floor, we would be allowed to have 2 means of egress just up to service that unit at the 4th floor.
yes, as long as the bi-level unit at the 4th and 5th floors has access to 2 exits from its unit. So as long as like that, so as long as the whatchamacallit, the way it's phrased specifically in the code is like you know, like if the dwelling unit meets the rules for a single exit space, and then once you leave the unit you have access to 2 exits, or the unit itself just has access to 2 exits, or and like has like 2 unit entry doors that lead to 2 independent exits, then that'd be allowed.
So arguably, then this could simply go from the 4th floor down and out.
Yeah, it could.
So basically 3/5 space, only 60% of what's been priced would be required.
Yeah,
that's something that might work financially, Logan, or do you think?
No, but I have a different alternative that was actually something that I brought this idea up a year ago, and at that time it was shut down, but for the reason that it was shut down, I think it might be worth revisiting just from like a reasonableness perspective. So wait, so that I can't screen share. Could you?
Yeah, I can stop.
Cool.
Yes.
So they have they make these all the way up to like 40 or 50 feet, and these are very reasonable in cost. What these are basically, it's an this would go off the back of the building. This would and I can even take this up to the 5th floor, not just the 4th floor. But effectively this cage would be a caged in ladder, so it's like, you know, from fall protection very safe. Cost wise, as you can see, like, you know, for each 20 feet, this is like $2,300, which I am not coming here saying that I don't value life safety. I 100% do. I just want to kind of find the intersection of being reasonable cost wise and achieving almost the same goal, because right now my project is literally like bankrupt and upside down, and we, you know, all don't want that, obviously. So like if we would propose this being allowed, then this would be perfect. And this would, you know, be let's just say installed, it might cost me for 2 of these, you know, with installation fees and everything, like 10 grand. And that's an investment I'm 100% willing to make. And it will, you know, make the project work. The only reason it was shut down a year ago was there was I forget which member it was that mentioned it, of like a firefighter with his like oxygen tank or something like that couldn't make it up this. But I mean, I guess from like a reasonableness thing, like I understand there's always those like what if scenarios, but I mean, I guess me getting out of the building, like as the resident of the 4th, 5th floor unit, is kind of like the main concern of just me getting out. In terms of like getting in, like, you know, firefighters have ladders on trucks and all sorts of ways to get, you know, into a building. And we also do have one staircase that, you know, would be 100% compliant, easy, you know, all those things for them to get into here. And you know, there's I know they're not supposed to use an elevator, but there would be an elevator in building to get up there as well. But you know, this kind of cost wise gets us to like the same goal in a reasonable manner. And I think would be I kind of hope for some reasonableness here to kind of work for all parties.
Wayne, do you want to caucus?
Yeah, I do. Okay. All right, give us a minute.
Hello, guys, you there?
Yeah.
Yeah.
Yeah, you know, I try to, you know, just, you know, put in my 2 cents when I think's needed. So from a fire perspective, like we've talked before about 2 exits from buildings around this high and the need for them and why the need for them. And again, everybody sympathizes with cost, right? I mean, everybody's out there on a budget right now. I think everything's too darn expensive, but I think the whole presentation had to do mainly with the hardship of money. And I don't know if that's really a reason for a variance, though. If, you know, but I do get it. So when you're talking buildings this high, those people on the, you know, the 4th and 5th story, even if it's not him, I mean, one day he may want to sell it, sublet it, whatever he's going to do. So you know, though I think the presentation was fine and he makes some very good points, I don't, you know, my vote, if I had one, would say I still think he needs to follow the code. That's all.
Okay, we're going to caucus.
Wayne, you're on mute if you're trying to talk.
Okay, can you hear me now?
Yes.
Okay. After going over this, we have what we need to tell you guys that we're going to require as of the provisos that was put in before is you must provide a new non-combustible exit stair meeting the width, the rise, and the tread dimensions of the fire escape at the rear of the building from the 4th floor to grade. It could be a spiral staircase at 5 foot in diameter. And then We have a NFPA 13 fire protection system and NFPA 14 standpipe. Matthew, that's required, right? That's not a proviso.
Oh, what's that again? What's specifically in there?
Yeah, on provide an NFPA 13 fire protection system and an NFPA 14 standpipes. That's a requirement, isn't it?
Yeah, they need those anyway.
Okay.
Yeah, okay, yeah, I know.
'Cause it's a
exactly, but
5-story
it's not a
building.
proviso, but
Yes.
the thing is it provide 2-hour rating between all units, provide horn and strobes and fire enunciation at the roof deck, grant variance for exit remoteness of a new stair to proposed interior stair tower, grant variance for close distance of new exterior stairs to property lines, and record all necessary easements. Now, that's, we have to be consistent in what we do. We can't give one person that, like what with you guys, to do something different than we would anybody else. And so we have to have that second form of egress from the 4th floor down. And and we'll give you the variances on the closeness and the remoteness, but we have to do that. We can't do away with it completely. So, anyone else have anything to say on that?
One question I do have, it could just kind of help with offsetting things here. The project that Gabe presented before this was 225 Quarry Street. I have 2 different architects. One's a new construction building, one's renovation. Same property, same owner, which is myself. We have a standpipe on Quarry Street, and the next door neighboring property to myself also has standpipes in the event of if they were to, like, if a fire were to occur, so like there's a ton of access to water for a fire truck. Would it be possible for us to remove the standpipe requirement on 151, but keep the NFP 13 system and whatnot, which basically we already have tons of standpipes in proximity. God forbid there were a fire on like adjacent projects, and it would just kind of help us all get where we want to, as just a last kind of idea.
Is there a stair tower that is accessed from both buildings, or are you just talking about it would be in the next building over?
It would be in the next building over.
Okay, yeah.
Yeah.
Because I've seen a situation where there was a shared fire tower with 2 buildings having access to it, but that's not the case here. Yeah. So John Dimes can really maybe speak to that, but.
So in your specific building, you're wanting to forgo the requirement for the standpipe in that building? Is that what you're asking?
Correct. I'd be asking if that would be possible, since we're doing it at like the adjacent building, and also the next door neighboring building next to me already has one in it as well.
Well, if we're fighting a fire in your building and we're going up your stair tower, how would we be? In other words, the standpipe is really for, we have a bag, what we call a high-rise bag or a second-in bag. That usually either has 150 feet or 200 feet length to it. So instead of pulling off 3-inch line, dragging it up your stairway up to the 3rd, 4th, 5th, 6th floor, and then hooking up an 1 3/4 line to flake out, it gets us in service quicker by just grabbing the bag with a gated Y on there, attaching it to the standpipe, and we're in service a heck of a lot quicker, because it does take time to do that. Having adjacent properties, having that standpipe really doesn't do anything for us with regard to getting in service any quicker.
Got it. Understood. Okay.
Okay.
All good. Well, I appreciate the flexibility you guys have shown. Thank you.
Okay, guys, good luck, all right?
Thank you.
All right.
Thank you for your time.
Cool. Thank you.
Okay, you're welcome.
Cool.
Okay.
Does anyone know who that person, Alex Canady, was? That was on the,
Who?
Alex Canady was on it the whole time, but I don't know who he was and for what case.
Yeah. Don't know.
No idea.
I guess
I
nobody
think-
can hear me. Can you hear me now?
Yeah.
Yep.
Okay. All right, Phil left. He has to go get his train. John, we're finished now. I don't think there's anything else.
Can we stop the recording, Debbie?
Sorry,
Okay.
I have to stop the recording. I forgot about that. All righty.